Collins & Co.'s not-for-profit conference, Be Empowered Through Knowledge, is designed specifically for the not-for-profit sector. Our speakers are experts in this sector, and their practical approach provides not-for-profit board members and management with the opportunity to improve their skills and knowledge across a range of specialist topics. The conference also provides a great networking opportunity. Partner Fabio Camerano introduces our next speaker.
Derek Mortimer. He's the principal of DF Mortimer and Associates. DF Mortimer and Associates is a boutique Melbourne-based law firm practicing exclusively in the not-for-profit and charity law. Derek's clients include private and public charitable foundations, trader associations and religious institutes. Without further ado, I'll introduce you to Derek and please give him a round of applause. Thank you.
Welcome everybody. I'm really looking forward to speaking to you about mergers, social enterprises and other collaborations. Before I begin, listening to Chris Varney telling us how he struggled through trust law, my experience is a little different. I came to the law much later in my 30s, and I found Emeritus Professor Harold Ford's Principles of the Laws of Trusts like reading a Dan Brown novel, and particularly the sections on charitable trusts. So I hope some of my enthusiasm for the concepts and the cases and stories will come across to you. Now today I'm going to be speaking about mergers and social enterprises, their definitions, their structures, some of the processes involved, and hopefully at the end we'll have a little bit of time to also talk about other forms of collaboration if the mergers and social enterprises aren't going to work for you. What I'm going to do is pepper the talk with as many stories as I can. Hopefully they will inspire you or warn you, as the case may be. So we'll start with mergers. There is actually no definition, statutory definition of the term merger. There's a dictionary definition that says it's a combination of entities and whatever that might mean in whatever process it might mean. However, there is a definition of amalgamation, and an amalgamation I'll talk to you a little bit later about is a type of merger, and that definition and process is set out, for example, in the Associations Incorporation Reform Act here in Victoria. I have heard mergers spoken about in the not-for-profit sector with various terms such as integration, marriage, partnership, or merger. It certainly isn't a partnership. Partnership requires two entities, such as lawyers, for example, who continue to exist during their partnership, but the partners can transfer rights and responsibilities. So if a partner makes a mistake and skips the country, you can then chase the other partners up to remedy the defect. The essential thing about a merger is that at the end of the merger, an entity ceases to exist. So when people speak about mergers being perhaps a marriage of two entities, I'd suggest that their concept of marriage is a little bit outdated. These days we recognise both entities in a marriage. So conceptually speaking, there are really only two types of a way a merger actually comes about. In one case, you have one not-for-profit becoming part of another not-for-profit, and that first not-for-profit then winding up or ceasing to exist. And in the other case, you have two or more not-for-profits that merge to create an entirely new not-for-profit, with the first merging not-for-profits then ceasing to exist. So in one case, it's essentially one not-for-profit remains in existence, and in the second case, which is an amalgamation, where an entirely new not-for-profit is created. Which one suits you, suits your own circumstances, depends. Obviously, with the amalgamation type, you need to create an entirely new not-for-profit, whereas with the merger, requiring one not-for-profit to merge, transfer its assets into the other not-for-profit, it's a different process. But I put to you that the essential part about it is that at the end of the merger, one entity or entities cease to legally exist. All of their assets, their human resources, their operations have been transferred to the merged entity, and that initial not-for-profit then takes steps to wind up or otherwise cease to exist. I want to speak a little bit about amalgamation, because amalgamation is one type of merger, and it's set out fairly clearly in the Associations Incorporation Reform Act. So it's my qualification that mergers don't have a statutory definition. Now sections 17 through to 21 of this particular Act describe quite simply, in my view, how a merger can actually occur through amalgamation. And it basically says that the secretaries or the committees of both merging associations agree to amalgamate. They agree on a new set of rules, and they agree on who will be the board members of that new merged or amalgamated entity. They then apply to the Registrar of Associations at Consumer Affairs. This is all set out in the Associations Act. And the Registrar checks the application to make sure it meets the requirements, and then declares the new association, the amalgamated association, as coming into existence. Now, the important part about this is that purely as a legal process is that the Act says that at that point of declaration that the amalgamated association has come into existence, then all of the assets, operations, contracts of the previous organisations are subsumed into the new amalgamated association. So without needing, from a legal process point of view, without needing to transfer assets, the contracts with employees, the titles to land, instantly by legal process, provision of the Act, then become the assets of the new amalgamated association. And at the same instant, the previous associations cease to exist. So it sounds like a very simple and, in my view, from a legal process point of view, a very simple way of going about things. That's not to say that you shouldn't then go to the titles office and actually have names changed, contracts changed, etc. But it sets out very clearly, in my view, how an amalgamation works. And this idea that at that point of amalgamation, all previous rights and liabilities with the previous organisations no longer legally exist. Is that clear with everyone? I will stop a little bit after we've spoken about mergers to answer any questions, but if you do have any burning issues, please feel free to put up your hand. There are a number of things to consider with mergers. Mergers come from, or the push to have a merger can come from all sorts of areas, from board, from CEO, from members, and some of you might be aware that government funding agencies have been encouraging not-for-profits in some areas to consider merging as a way of reducing essentially reliance on government grants. Some of the things you might want to consider are whether the two or the entities that are going to merge have similar purposes. Obviously, if you have a charity that's a registered environmental organisation, how easily is that going to merge with an entity that is a public benevolent institution? I could imagine circumstances where it might work, but on the other hand, the purposes may be so disparate that the two can never really get together. A merger can be a very simple process, especially if you have an association or a not-for-profit that has small assets, a few dollars in its bank account and relatively small operations. But at the other end of the scale, this can be is equivalent to a sale of business involving complex considerations of employees, who is going to be transferred, long service leave, superannuation, who actually owns the printer, copier machine, is it under lease or is it owned outright by a merged entity, etc., etc. If you're a housing agency, the Registrar of Housing would certainly want to know what you're up to, so there's other people you might need to speak about. And this is where you might start considering legal documentation to help you through the process. At the very minimum, you'd want some sort of due diligence checklist to actually identify what your assets are, what your liabilities are. You might also need to consider deeds of agreement between the entities that are about to merge, A deed of agreement is a binding contract that, providing certain conditions are met, such as member approval, the two entities will effectively merge. More commonly, though, you'll find an MOU is sufficient. An MOU doesn't create legally binding expectations on the entities that are about to merge, but can set out a process by which the merger might actually operate. So there are a number of legal documentations that you might want to consider going through a merger process. It's important also to consider what happens once the merger has gone through. In an amalgamation, I mentioned the merging entities cease to exist, but if you've merged from one entity into another existing entity, then you have an entity that is essentially a shell without any operations, and you'll have to look at winding that up. There are ways to wind up: cancellation, a voluntary wind up. Sometimes it might involve a liquidator, other times it might not. It's worth just mentioning, though, and I'm not certainly suggesting that a liquidator is the best way to go, but some of the reasons for having a liquidator, apart from its mandatory requirements if in certain circumstances, is that a liquidator has skill in identifying assets and liabilities. They can ensure that any transfer of assets is done in a timely manner. And I'll just give you an example. A colleague of mine in Horror Story, in the previous Associations Act regime, was called in. He found that the association that had merged had applied for cancellation, duly noted by the registrar. The entry in the Government Gazette was made, so this entity had ceased legally to exist. And it was at that time they realised that certain transactions hadn't been effected and that required board approval of this now no longer existing association. To save embarrassment, I won't describe how this problem was resolved, but it did require board approval. You can imagine if you tried to reinstate the association, it would actually have a new association number, so you'd actually have a new entity. So you could imagine legal concepts were being thrown around with abandon. These days, though, in the new associations regime, there's actually a specific provision for the registrar in cases where cancellation has happened and transactions still need to be effected, for the registrar to reinstate the association as if nothing had happened, allow those transactions to occur, and then finally wind up. So this is just a story about the need for process, to be very careful about locating all of your assets and liabilities and working through the process to finally, at the very last step, winding up and cancelling your ABN. So that might be a reason to have a liquidator, but there may be other ways that you can do that without needing a liquidator. What I want to do now is tell you a colourful story about a golf club. And for those of you who came to this session last year, you may recall I spoke about the Kingswood Country Golf Club in a different context. But I think it's a terrific example, with all due respect to the people who were in the club who I'm sure didn't find it a pleasant experience, but I think it's a terrific example to help people when they consider merging not-for-profits, because so many things were certainly done wrong in the view of the judge in the Supreme Court. So Kingswood Golf Club was located in Dingley. It had one 18-hole golf course. It was valued at about $54 million. However, it had some declining membership issues and started conversations with Peninsula Golf Club, which is based in Frankston. And Frankston, there were two golf courses there, and similarly were valued around $70 million. However, there was some debt on the Peninsula Golf Club land. A merger eventually was effected by the transfer of all Kingswood members to the Kingswood, transfer of all of the Peninsula members to the Kingswood Club, and a change of name of the Kingswood Club to what it is today, the Peninsula Kingswood Country Golf Club Limited. Now, that was the actual merger, but there was a great deal of controversy. There was a group within the Kingswood Club who said, we don't want this to happen. In particular, the idea of the merger, once it had been effected, was that the Dingley land would be sold and the proceeds then used to pay out any debts with Peninsula and basically use the 2 golf courses at Frankston. So there was a good deal of agitation within Kingswood prior to the merger and after the merger to prevent this happening, and it eventually went to the Supreme Court. To cut to the chase about the decision of the court, they found that the plaintiffs had delayed their application to the court, so they weren't successful in stopping the transfer of land or the merger. But for that technical issue, I think the plaintiffs had a good case, certainly if you read parts of the judge's the judgment. So I'll read a couple of parts. The first thing was on the 26th of March 2013, there was a heads of agreement signed, basically an MOU between Kingston and Peninsula. This was done by the 2 boards, and I'll just cite the judge's opinion about the nature of this head of agreement. One may think that the heads of agreement indicated a greater degree of agreement on the merger than merely to look at each other's business for a possible merger of the 2 clubs. In my view, said the judge, there may be much to suggest that the board may not have been even-handed on the stay or go proposals that were thereafter considered. So in other words, the judge is saying that the heads of agreement was, if you like, predisposed to a merger without actually discussing the merger even-handedly with members of the Kingston Club. Later on the 26th of August 2013, an information booklet was distributed by Kingston to its members, and it extolled the virtues of the merger and in particular how the merger and the sale of the Dingley land would be used to pay off the debt at Peninsula. Now, if you think about this, this is an information booklet to the members of Kingston talking about the benefits of the merger, the benefit being a benefit to another entity, the Peninsula Club. So the general meeting was held on the 17th of September 2013. At that meeting, there was a resolution passed to merge, of which 67% of members agreed and about 20% disagreed with the merger. Now, I asked this question last year, and just to check your own understanding, if you can answer the question correctly, well, you're in line to be a Supreme Court judge. What do you think was wrong with this resolution? Yes? 75%, a special resolution. So the resolution the judge found wasn't done correctly. It needed 75% of members present to approve the merger. So it went to court a good year later, and just about at the time that the Dingley land was being put up for potential sale. It was put under the oppressive conduct legislation of the Corporations Act, where members can take action, prevent actions of a board where it's prejudicial to the interests of the organisation as a whole or to the interests of particular members. And the judge, as I say, wasn't impressed with the way the process was handled, and he said that the process was unfair, that members hadn't been given an opportunity to fully discuss the stay or go proposals, whether the Dingley land could be sold or another way of retaining that land rather than selling it. He also found that perhaps there was a bias in favour, more in favour of the interests of Peninsula than in the case of Kingston. He said also, perhaps I should quote, I find that the substantial object of the board in admitting new members was to give effect to the merger agreement. That is, the merger agreement and not to the benefit of the club. So, in other words, the board was not acting for a proper purpose in deciding to go ahead with the merger. So these are serious allegations and opinions provided by a Supreme Court judge, and that's why I'd suggest to you, even though this case, the plaintiff failed to have his injunctions because he was out of time, it shows that this whole merger process, which involved millions of dollars and many members, there were over 1,000 members in the Peninsula Club, for example, could have fallen through people's fingers just because members weren't properly consulted and there wasn't an even-handed approach to considering the merger first before then going ahead. The judge also said that the constitution of Kingston should be changed before they could even move a motion to admit members from Peninsula, which is an interesting thing for lawyers. Perhaps we don't need to worry about having those changes, providing members are properly consulted, with due respect to the judge. But anyway, in that case, it shows you how quickly these things can unravel if there hasn't been a proper communication with members and following process set out in the Constitution. Yes? So the question was about whether the management of the board used proxies to get their way. I couldn't find reference to that in the judgment. Presumably there was due notice given, the 21 days mandatory notice. People were invited perhaps to submit their proxies to the chair, but that would be what I would expect, but I can't tell you from the judgment. So you might want to just repeat that a bit more loud. Thank you.
Yeah, I'm just saying that some of the football clubs put a lot of things through. Members don't like with
So maybe you're making a distinction between dummy voting, or we hear about that in the political process too. But certainly, I imagine many of you would be aware that, subject to your constitution of your own not-for-profit, there's often a provision to allow members to put in a proxy. That is, they don't need to attend in person. They can simply ask their chair to vote on their behalf. They would normally sign the proxy, so if somebody else has signed other than the member, then it's fraud. Wouldn't to put a point on it. Yeah. Okay. Yes. That's where you come and speak to lawyers about that. But there is provision. We've transferred land. We once did for a church that merged with another church, which was an interesting exercise. Was it a sale of business? Do we need to include the pews and the Bibles and the pastor as well in the documents? But essentially it was just a transfer of land, paying off a mortgage to the two entities. It's usually in consideration of an agreement. Gift isn't the best word to use in the transfer documents, but providing the standard due diligence is followed and the sale of land, section 32 of the sale of land, it's a fairly standard process despite it. At that point, I should say, I had a query to our insurers, the Legal Practitioners Liability Committee, which run a GST hotline, because I got into trouble. Is this a going concern at church? They're nice questions to ask and questions that lawyers should ask, otherwise they might find themselves with a GST liability issue against them. But they are some of the issues that might need to be considered. It wasn't a going concern. I think God is still a going concern, but as far as GST law, it wasn't required. Okay, I'll move on to discussion on social enterprises now. Oops, what have we got here? Okay. Seem to be going the wrong way. Okay, social enterprises. What I want to speak here about really is some basic structures about how social enterprises can be put together. And I'm conflating the idea of enterprise with the idea of entity. So sometimes you can have an enterprise within a not-for-profit that, in my view, could be called a social enterprise. But for the sake of brevity, I'm going to talk about distinct legal structures as being the legal enterprise. Now, a social enterprise, basically, I think we've lost the definition there. There isn't a definition of social enterprise, but social traders provide a definition that is reasonably well accepted within the not-for-profit space. Yes? Thanks very much. Okay, so social traders say it has to be an entity that has a public benefit mission. It reinvests its surplus back into the organisation, and a substantial part of its activities are actually trade. So you can imagine many not-for-profits, say, that run clothing bin operations or op shops. It might be a small part of the overall operations, which may still depend heavily on donations and grants. That wouldn't perhaps meet the definition of social enterprise. So essential part of it is that trade is taken on and that the surplus is then reinvested. So conceptually speaking, two types of social enterprise. This is where a not-for-profit owns another not-for-profit, or the enterprise members comprise not-for-profits. And I'll give you an example of my very first foray into this area of law in a moment. The other type is where several not-for-profits come together and form a proprietary limited company. Now, a proprietary limited company is usually a for-profit vehicle. It's a shareholder arrangement, so the not-for-profits actually become shareholders of this new not-for-profit entity. In one of our clients set up a proprietary limited company of which it was the sole shareholder. It was an environmental organisation, and it set up a proprietary limited company to run a food cooperative, a food bank selling organic food. And they thought, for many reasons, that it was best to separate the two entities, although perhaps they could have run the food co-op within their operations. So there are many reasons to consider whether you need to go into a social enterprise or not. The legal structure might seem to be a mere technicality, but the way you structure it can affect, for example, the separation of risk between not-for-profits and the social enterprise, the ability to attract capital if you want to attract investors in or need to attract investors in, also the separation of brand. For example, Qantas and Jetstar essentially connected to each other, but they're two separate entities, so you can have a different branding on what Jetstar offers the public as distinct from Qantas. Also important to consider are the tax consequences. Is it going to affect your income tax exemption or DGR endorsement, for example? If you set up a proprietary limited company, well, it's subject to the normal company tax unless you address that properly, such as through franked dividends to the not-for-profits, which can be refunded. What I want to do now is just briefly talk to you it's concepts that we lawyers use in charity law to help define what might be included in your enterprise and what perhaps might not be included. And these are once again drawn from cases and examples. The first way I describe activities that can be undertaken by a charity in these enterprises are the intrinsic activities. That is, the activities that, by their very nature, are charitable. So, for example, housing agencies provide rooming houses to people who would otherwise be homeless, and they charge, in some cases, a subsidised rent. You could say it was a social enterprise because there is a trade involved, that there is a rent paid, but the very nature of that activity of helping people who would otherwise be homeless is intrinsically charitable. So that's one sort of activity that could work in a social enterprise. The other type of activity is an activity that is neither charitable or uncharitable, it's ambivalent. And this was the case in the Word Investments case in 2008 that went to the High Court. Now, Word Investments ran a funeral business and transferred the surplus from that funeral business to another not-for-profit called Wycliffe Bible Translators for obvious purposes there. There was a little bit of humorous dialogue with Justice Kirby in the special leave application by Word to appeal to the High Court, dialogue with counsel. And Justice Kirby said, well, we all go to God. We all have to meet our Maker at some stage, whether you're an unbeliever, a heathen, or a Christian or not. So Word, it wasn't really catering to advance the Christian religion. It was there, anybody could go and have their funeral business serviced, whether you were Christian, Muslim or an atheist. So his comment was, Word investments didn't seem to really have any particular defined charitable purpose. But the rest of the High Court tended to disagree with Justice Kirby's ideas and came out with what's called a natural and probable consequences test. And this is where an activity, such as a social enterprise running a funeral business, has a natural and probable consequence of a charitable purpose. And in this case, the natural and probable consequence was a surplus from the funeral business, which was then given to Wycliffe Bible translators to use to translate Bibles. So I've given you two ideas. There's the intrinsic activity and the natural and probable consequence activity. And in my view, if your activities that you're thinking for your social enterprise fit within those two ideas, well, then it's likely you could have a social enterprise structured as a charity. One word of warning, and I'll talk about the Australian tea tree oil case, which is also a 2008 case, which is where the activities of this entity were so fatal to its ability to be charitable that it didn't get its income tax exemption. It actually went into liquidation. Now, in this case, Australian Tea Tree Oil was a company limited by guarantee, a familiar not-for-profit structure. It had a purpose of advancing scientific research into tea tree oil production. There was no prohibition on distribution of income to members. So you would say, okay, well, that sounds like a not-for-profit or a charity. It even has a charitable purpose. But as it turned out, its only business, and it was you could call it an enterprise, was to undertake research for a commercial syndicate of tea tree oil producers and distributors. And that was its only business. The court found that essentially Australian tea tree oil was set up to further the commercial interests of the syndicate, and it was particularly concerned that the research that Australian tea tree oil actually produced as a consequence of its arrangements with the syndicate was commercial in confidence. So the research couldn't be disseminated to the public, could only be given to the commercial providers. So this is an example where public benefit wasn't met, and the court said you're not entitled to be a charity. So if you're considering an arrangement that might be an exclusive arrangement preventing the research of your charity or the activities of your charity from benefiting the wider public or a section of the public, perhaps it's not an activity that is best suited for a social enterprise. So I'm going to talk now very quickly about a couple of examples of mine. This one's a company limited by guarantee, which is wholly owned by other not-for-profits. That is, the other not-for-profits are the members, which have a right to vote in directors of the company limited by guarantee. This project, the Landcare Revolving Loan Fund, was my first project whilst I was completing my undergraduate studies in 1998. It was based up in Benalla in northeast Victoria, and the idea was that a separate company limited by guarantee called the Landcare Revolving Loan Fund was established. It was endorsed as a DGR, so it could attract tax-deductible donations and was income tax exempt. And its whole purpose was to provide microfinance to farmers to help grow trees for commercial return, but also for an environmental and overriding environmental benefits in line with catchment authority requirements. The Landcare Revolving Loan Fund members were 5 landcare groups, which were themselves associations. Now, it was a pilot project. I can tell you it was successful in that it showed that money could be obtained. The Goulburn Murray Credit Union was involved so that borrowers could repay their loans directly to the Goulburn Murray Credit Union, to the Landcare Fund's account there. And it also showed that the farmers would indeed repay their loans, grants could be given, and indeed the tax office would give DGR, which was in a way a seminal example of social enterprise at about the time when the Social Entrepreneurs Network had established, but the idea of social enterprise was still fairly new. So it's a good example, in my opinion, about how the tax office will be flexible towards enterprises that have a trading purpose and even some commercial benefit to people. The report is available from the Rural Industries Research and Development Corporation, but the Landcare Fund itself was wound up after the pilot project had ended. The second example I want to give you is where two not-for-profits come together and set up a proprietary limited company. Oops. So in this case, with permission of my client, they've set up a company called ATEC Australia International Proprietary Limited, and the two shareholders are Live and Learn Environmental Education Incorporated, which is based in Melbourne, and Engineers Without Borders Limited, which is also based in Melbourne. Both of these entities are charities and with DGR. And they've set up this for-profit entity called ATEC. The purpose of ATEC at the moment, through a shareholders agreement, is to run a social enterprise of developing and selling biodigesters. Biodigesters being essentially a large plastic bin that processes waste and creates methane and organic fertiliser as a consequence. So the two shareholders are there, 50-50. There is capacity to accept other investors if that was ever the case. What they have done is set up a branch office in Phnom Penh, Cambodia, and a branch manager, Ben, has been appointed, and they are now starting to roll out biodigesters into rural villages in Cambodia.
3 hours north of Phnom Penh, on the edge of the Tonle Sap Lake, villagers cut and stack firewood. An unremarkable activity, except logging is illegal here. It places enormous pressure on the lake's watershed. Trees are cut faster than they can grow. The use of chemical fertilisers and untreated sewage in these remote villages further damages this fragile environment. But Aussie engineers believe they have an eco-friendly answer. Engineers Without Borders is testing a device it hopes will curb wood burning, process manure and sewage, and reduce the health costs from pollution. It's called a biodigester, and it makes gas for cooking and fertiliser for the garden.
It's a very basic looking system. How does it work?
Yeah, so with a biodigester you put the waste in here. It then takes about 30 days to run through the system. During that time you're producing enough gas for your cooking needs. And then you have your organic fertiliser coming out here, which can be used for your rice field, for your vegetable crop, etc.
The gas is stored in a bag in the ceiling. A ready supply saves money, but more importantly, there's no pollution from burning wood. Mealtimes are healthier and happier.
The change is that my children now are rarely sick with no more breathing problems.
Farmers also prefer the natural fertiliser produced by the biodigester.
It makes the soil soft and helps the rice grow. It's much better than using chemicals.
It's taken 5 years to build and install 30 biodigesters. Engineers Without Borders aims to have 2,500 by the end of 2017.
By having a system like this, our aim is to be able to reduce that need of collecting wood or cutting down trees and reduce the deforestation, which leads to things like soil erosion and upsetting the ecosystem of the Tonle Sap.
The biodigesters float when it floods, but this year that may not be a problem. The monsoon rains haven't come, and the Tonle Sap is now facing one of its greatest ever challenges, drought. In Traipang Chan, on Cambodia's Tonle Sap, Craig Leeson, 7 News.
Oh, isn't that exciting? I think it's fantastic how two not-for-profits are coming together. They've set up this enterprise that will sell biodigesters at a very reduced rate to villages in Cambodia. I wish they'd do it here. I think first world countries could benefit from the same thing personally. But I think projects like this are inspiring, and hopefully it's inspired you, as indeed the Landcare Fund, which was a microfinance project. And I hope that the Kingston Club case will be a salient reminder to you about the necessity to be careful when you're engaging in mergers and ensuring that everyone is on side and processes are followed. Now, having argued, how are we going for time, by the way? Have we got 5 minutes or so? Thanks, Fab. Having argued passionately for mergers and for social enterprises, there may be other ways to achieve your aims as not-for-profits without needing to go through these, what are complicated transactions. I mentioned there is a push within some sectors of government to encourage not-for-profits to merge purely from a cost-cutting perspective. So, for example, you might consider co-locations where a number of not-for-profits merge isn't the right word, but where they come together under one roof and share administrative resources. And there are quite a number of these hubs around Melbourne already. So you might have, for example, a charity that takes out the head lease and then has sub-lessees being other charities who have their own dedicated office space and perhaps share a secretary or other administrative or accounting sections. So that's one thing to consider. Partnerships, I mentioned partnerships. Personally, I'm not in a great advocate for partnerships because of the idea that one partner has to bear the risk of the other partner if the other partner makes a mistake. However, there might be a case to have a partnership between not-for-profits in certain cases that might be worth considering too in a legal sense. NFP peak body memberships, I'd better call this because the blurb introducing this in this seminar talked about the question, is membership of a peak body a merger? Now the answer obviously, if you've hopefully been listening to me, is once you've merged the entity ceases to exist. The answer has to be no, because as a member of a peak body you're still an entity. But consider this example. I have a client that is a charity that joined a national peak body. And so it was the corporate member of the peak body. The client also had individuals who were its own members. But as a corporate member of the peak body, it was obliged to follow the rules and policies of the peak body, and found very quickly that the peak body was asking for the database of all of my client's members, ostensibly to affect a group insurance policy to cover all of the members, but also there's the possibility that the peak body could then directly contact members, the individuals who were members of my client, the body corporate. So that's starting to raise concerns. It then transpired that the peak body was advertising and calling for public donations, tax-deductible donations, so that the peak body could use that money to run programs run by my client, all without my client's knowledge. And it was this point they gave me a call and said, well, is this a merger? It feels like a hostile takeover. The peak body has come in and presumed that it could get access to our members and as well as solicit donations on behalf of programs. And if that behaviour had continued, essentially my client would have ended up as a shell and without really anything to do except hold an annual general meeting to meet statutory requirements. Now, I'm not suggesting that membership of peak bodies is something you shouldn't do, but considering what you're going to get, are you giving up any rights? What obligations might be expected of you? Can you still exist independently without the need for the peak body? So the answer, no, you're not merging when you become a member of a peak body, but remember to look at what the deal is, essentially. So I hope that's a humorous story. It certainly was discomforting for our client. Well, that's really come to the end of my presentation. I've spoken to you about mergers, how you can have mergers of one entity into another or several entities merging to create an entirely new entity, how assets, human resources need to be transferred and you might want to follow processes through a deed of agreement or an MOU or due diligence. I've talked about the Kingswood Golf Club matter, which shows how process can come very quickly unstuck. I've also talked about social enterprises, which essentially are enterprises that turn the surplus back into the mission of the organisation, and giving you an example of two common structures where not-for-profits become a member of another not-for-profit, or where not-for-profits join to set up a for-profit PTY company. And I've given you some ideas also to consider for other types of collaborations that might achieve your aims as well. If we have a moment to take questions, Fab.
Probably shout that. I'm just interested in why, in the last example you gave, the social enterprise, why they formed a company. What the benefits of forming a company?
Well, perhaps I'll speak generically. Some of the benefits having a PTY company are separating the risk of that entity. There was a joke, and I have to tell you, the joke was taken seriously, but you might have seen the methane bag hanging over the village's house, the exploding methane scenario, and obviously they've taken it seriously. Apparently it's not under pressure, so you wouldn't get a fireball effect. But one idea is to separate risk. A PTY could also, in theory, accept new investors. Let's just say the biodigester project took off across countries. Other investors, even for-profit investors, might be looking at injecting some capital, and perhaps the two current shareholders might say that they were funded with a grant from Google, but let's say that it wasn't sufficient. They needed further capital to expand, so they might look at investors that way. A PTY company is an easy way to attract for-profit investors. It's virtually impossible, I think, really, for a PTY or for a commercial investor to become a member of a not-for-profit, which simply gives membership rights to vote and no capital return.
You mentioned you read a really good book on trusts in the very beginning of the presentation. I was wondering if you could repeat the name of that book.
Principles of the Laws of Trusts by Emeritus Professor Harold Ford, Melbourne University, and it comes out regularly. I think it's now edited by someone else, but it's the standard textbook, and I can remember reading it through and learning about Pemsel's case and all of the other fantastic cases in charity law and charitable purpose, and thinking, this is really interesting. And that eventually took me on a trip to the United States in 1993 when I was 31 to look at microfinance projects and land trusts that I then brought back to Australia, and we set up the Landcare Fund, and I commenced my legal career. So I've got Emeritus Professor Harold Ford to thank for that. I should also mention, whilst we've got a moment, thanks to the Sisters of the Good Shepherd no interest loan scheme, who provided us with a lot of advice early on in around 1997, 98, when we were setting up the Landcare Fund. They certainly were the very first, certainly before us, with microfinance in Melbourne. Good. Well, thank you very much for listening to me, and you should feel free if something comes across you during the day. Advice is given generically but freely. Thank you.